Last speaker for today is Lonneke Stevens, also from the Netherlands, but this time from the Vrije University in Amsterdam. And she's going to ask the question whether struggling judges need a probability help desk.
Yes. Thank you. Before I start, I'd just like to share an observation with you about the past two days. I've heard so many talks from so many different perspectives. We have different disciplines and we have different jurisdictions and we have academics and practitioners, and sometimes my head is just having trouble trying to process all this information. Being a Dutch criminal law scholar. So I guess now's my sweet revenge, presenting you a Dutch talk. And this talk is about a question that's been bothering me for some time now. Like I said, I'm a scholar in criminal law, and I've set myself the task of translating non-legal theory on fact-finding into guidelines criminal court judges can actually use and understand, and that's already quite a struggle if you're trained as a lawyer and not trained as a mathematician and not particularly gifted in that respect. But there's also this this nagging question, and that question is there really a need for criminal court judges to reason with probabilistic models like Bayes when they decide standard cases? And let me first explain what I mean with standard cases. For me as a Dutch lawyer, standard cases are high volume crime cases in which the evidence is often not clear cut. It's not too complex but not clear cut. The defendant denies or is silent. The evidence mainly exists of witness statements, and often there's no forensic evidence. It's usually cases in which judges need to make a fast decision. So you can think of shoplifting, burglaries, nightlife violence, domestic violence, that kind of cases. And a great deal of the work of a criminal judge in the Netherlands exists of deciding in this kind of cases. And one important reason for me to address this rather fundamental question, and I'm also triggered a bit by the workshop theme that preaches a hallelujah, is that criminal court judges themselves generally do not feel like they have to do things differently. That they have to use rational reasoning models when they decide cases, so rational models like Bayes. And for example, the president of a Dutch Court of Appeal, he claimed that, and I quote, "Experience and intuition of a judge are not inferior to the rational models of science." And another thing is that the argument that's always used to claim that judges should use rational models of proof is the occurrence of miscarriages of justice. But these miscarriages of justice happen in complex cases and they are considered to be exceptions by the judiciary. So I also know, and my question also comes from that I'm a bit familiar with practice. I'm just like Marieke, a deputy judge or a substitute judge, whatever you want to call it, and myself. So that means that a few times a year I have to decide cases of my own. I'm in a court of three, so with 3 judges, professional judges, and I have to make this decision on these standard cases. And what always strikes me is the huge gap between the world we're here today, this week at this conference, and the world of the legal practitioner, so the criminal court judge, who's deciding cases day in, day out in a rather rapid pace. So, and to illustrate my problem, I'll give you an example of a case I was involved in myself. In this case, a drug addict, he was suspected of stealing a bike in the red light district of Amsterdam. And that's probably the most Dutch case you're ever going to get. Normally, this case would be brought for a single magistrate because it's really a simple case, but for several reasons I won't bother you with. We had to decide on this very simple case with 3 judges. And what happened? Well, the police reported that the suspect, a known thief and addict, he was seen circling suspiciously around the bike, fidgeting in the lock with some iron thing. When no one was around, and eventually he drove away on the bike. The suspect fiercely denied that he stole the bike. The bike was his cousin's. And naturally, I was very keen on having no tunnel vision here. So this guy was a drug addict, and his criminal record was from 30 years ago and 50 pages thick and everything. But maybe this time he didn't do it. He denied, and he denied fiercely. So, and the fidgeting in the lock, well, it could be that he was just having trouble with his key, right? And I was also a bit skeptical about the police report that was obviously written down in haste, and it contains some small contradictions. So I suggested to my fellow judges that we should set up an argument with alternative scenarios. So we would write down the guilty and the not guilty scenario and scrutinize the evidence from both scenarios, and then determine which scenario, under which scenario the evidence was more likely to occur. Well, we did not reason with scenarios, and we convicted the suspect. And I cannot tell you what was said in chambers, but I could tell you what could have been said by a judge to me, what probably would have been said to me, that I was unnecessarily complicating an uncomplicated case, and that the evidence was enough and convincing, and that this suspect made a living from stolen bikes, and if the bike really were his cousin's, why didn't he call the cousin in for questioning, and where was the key? It wasn't found on him when he was arrested. So then I thought, okay, maybe I am complicating things, but I was still a bit uncomfortable about it. And of course, at this conference, we can think of many reasons why why judges should reason with probabilistic models. And I think, well, to my mind, reasoning with scenario is a way of reasoning with a probabilistic model. And maybe you don't agree, but then I'd like to hear that later. But how should we have done it in a case like the stolen bike? And would it have led to a better argumentation and a better decision? It certainly would have taken more time, and it's time judges don't have when they decide cases like this. So I'm fairly certain that if you want criminal court judges to use probabilistic reasoning, you first need to know what they do on a daily basis. You have to learn about what kind of cases they decide, and what kind of evidential problems they encounter, and get a grasp of how they reason according to law. So that's why I thought, oh gosh, I have to make a research program out of it. But I need to research high volume crime cases and see what kind of problems and difficulties judges have when they are reasoning with the evidence. And what have I done so far? Firstly, I have conducted research on the basis of case law analysis, so that's rather limited research. I've just started, and I've also done some explorative research on the basis of informal discussion with judges. I'm planning to do interviews with them, and that's very hard to organize because judges, well, they're rather closed shop and they don't really like talking about what they find difficult. But I've done something. I've done the case law analysis, and today I want to discuss four issues with you. Four issues that I've discerned as difficult in daily fact-finding. And these issues are, the first one is how to assess the reliability of a witness statement. The second one is how to decide on the strength of a piece of evidence. The third one is how to reason with alternative scenarios. And the fourth one is how to value information that's not in the evidence. So I'll start with the first issue, how to assess the reliability of witness statements. And that's a question a judge in the Netherlands often has to deal with. Just a lot of cases, the only evidence is witness statements. And they are crucial evidence. And the Dutch law demands that a statement is reliable. It can only be used if it's reliable. But how the judge should ascertain whether or not a statement is reliable, the law doesn't give any guidance. So the judge is free in selecting and assessing the evidence put before him. So my question was, if the law doesn't tell him anything, what kind of argumentation the judge does come up with? And I often found the consistency argument. So the judge reasons that the consistency within the different statement of one witness and the consistency of the witness with regard to details, they indicate that a statement is reliable. Inconsistencies, on the other hand, they are often not an argument for the judge that the statement is unreliable. So, and this is especially true for inconsistency with regard to details. So, in those cases, the judge, for example, reasons that, in essence, the statements are in correspondence. And next to this consistency, there's a whole array of factors that is used. It's like the certainty of the witness when he gave his statement, his sincerity, his limited intelligence, motives to lie, the fact that the witness is a suspect too. And none of these factors actually, in the verdicts I studied, they led to the conclusion that the statement was unreliable. And I'm not sure how to value this variety of factors and the way they are used. Some seem to make sense in general, but on the other hand, they seem not very conclusive. And the use of the inconsistency factor seems arbitrary as far as I can tell on the basis of the verdicts. So I think it's also interesting to see then that in almost all the cases I studied, judges also approach the reliability issue on the basis of the question, is this statement supported by other evidence? So what they do is scrutinize this particular part of evidence holistically. In a way judges are used to deal with information. They embed and verify the disputed piece of evidence within the story of guilt. And that's a mere confirmatory approach, and it's easy to criticize. So we'd be very curious to hear how probabilistic models perhaps could help to determine reliability, and preferably without numbers and without taking too much time. So, but maybe we can discuss that later. That brings me to my second issue, the strength of the evidence, or the weight or the value. I've heard different terms last 2 days. Well, strength, it's a concept that's unknown to Dutch law. What the strength of a piece of evidence encompasses, or how it should be established, the law, well, does not address these questions. But in case law, the strength of the evidence is discussed. And what you see is that judges use it interchangeably with reliability. And that goes in particular for when they're talking about witness statements. When judges, for example, talk about the strength of a witness statement, they actually seem to be determining reliability. They discuss factors like the difficult circumstances a statement was made in, or the mental disorder of the suspect. And but these factors, they address the question whether a statement can be believed and used as a reliable statement in court. And that's another question than what the statement actually tells about the guilt of the suspect. And in some cases, judges do not seem to realize that they are talking actually, or they are mixing up concepts. But case law also demonstrate that they mix up the concept for a reason. They have legal reasons for mixing up. It can happen that a judge has some doubt about the truthfulness of a statement, but he does not want to exclude it completely. And the Supreme Court of the Netherlands demands that you can only use a statement when it's reliable. So to the law, a statement cannot be a little bit reliable and be used a little bit. So if a judge wants to use a statement that was contested by the defense, about which he's a little doubtful about himself, but not too much as to exclude it, he marks the statement as having less weight or having less strength and uses it. So this example demonstrates that, well, judges don't really have a clue about the concepts of reliability and strength, but they use it in a way that fits their legal purpose. And I'm not saying this led to wrongful convictions in the cases I studied, but I do think it would be wise to have an idea that there are two concepts and two questions to be asked. Is it true what is said, and what does it say exactly about the accusation? My third issue, I studied reasoning with scenarios. We've had several miscarriages of justice in the Netherlands, and they fueled the discussion on how to ban tunnel vision. And with regard to judges, it was advocated that judges should not ask the question whether there's enough evidence to convict the suspect, so the question the law asks, demands them to ask, but instead they should always reason with a guilty scenario and a not guilty scenario, at least one other not guilty scenario, and the judge should assess the probability of the evidence under the assumption of each scenario. So a judge should even do this when the defense does not bring up an alternative scenario, so he has to make up a scenario himself. And I discussed this with judges and they're like, what should I choose? But that's the theory. And what do I see in case law when I look at alternative scenario? Well, I see that these words, I can find these words in verdicts many times. So judges know about reasoning with scenarios, but how do they actually do it? I've studied 27 cases, and what I've first of all found was in most cases that the judge does not reason with both the guilty and the not guilty scenario. He simply dismisses the not guilty scenario as one, not plausible, or two, not substantiated enough, and then reason that the evidence is enough to convict the suspect. So I think these could be very good arguments, not plausible or not substantiated, but it would be something to further research whether it was right for the judge to do it in this case, because I can't really do that on the basis of the verdicts alone. I would need the case file for that. When a judge does reason with scenarios, he struggles sometimes. And I've one example I'd like to share with you. There's a fraud case I came across, and in this case there was a guilty scenario, and there was the suspect set fire to his company building in order to get insurance money. And then there was a scenario the defense came up with, and that was the company was raided by 3 men who afterwards set fire to the company building. And on the basis of the theory, you would expect the judge to assess the probability of the evidence on the both scenarios and how they relate. So, look at both scenarios, but what the judge in this case did was he only looked at the not guilty scenario. So, the raid by the 3 men who set fire to the company. And he said that it could not be excluded on the basis of the evidence. And he acquitted. And my first intuition tells me this is odd. In the first place, this story is an odd one, but that's mainly because the verdict doesn't give me any information about this scenario, whether it's substantiated. So I cannot further test whether this story is really an odd one, or not plausible or not substantiated. So assuming then that the alternative scenario actually should have been taken into account, what is it I see here that this judge is doing? Well, I think what I see happening is that a judge does not know how to reconcile this method of reasoning with scenarios and evidence with his usual reasoning and the dichotomous decision he has to make. So the question the law asks is, the law asks to the judge is, can the accusation be proved? And then his method is to look whether the evidence is enough. So this kind of reasoning does not match with reasoning with 2 scenarios to the evidence. And then there's another problem Marieke talks about. In the Netherlands, we don't really have a clear standard of proof. So to me, what this judge does, I don't really understand what he does, but it seems that he somehow translates a method of reasoning directly into some very strict standard of proof. The alternative scenario cannot be excluded, so we quit. I don't think we could convict many criminals if that were the standard of proof. So to me it seems that he does not know how to handle the doubt that this method brings into the case. Of course, it's just one case, but I do think it indicates something. It indicates that if you would want judges to reason with, probabilistic models, this cannot go without teaching them where the reasoning ends and the law begins. And of course it would help if we had a clear standard of proof. But he has to know how to make the leap from doubt to decision. Then my fourth issue. This is something I have not researched on the basis of case law, but I've discussed with judges. I've been exploring through discussion with judges, so it's a bit of a explorative phase the research is in. But it's a question I'd like to discuss with you. It's the question that Marieke already mentioned. What to do with information that's not in the evidence? And Marieke mentioned the criminal record, but I have another example. It's the following one. There's a suspect that and he denies he committed a robbery. He says he was with his sister the night the robbery was committed, and his sister confirms his alibi. And this suspect is from a certain North African region and part of a criminal gang. And judges have the experience that these kind of suspects regularly use their sister as an alibi. When I talk to them, I say, yo, those sisters, we never believed them. And they see it all the time. It's common knowledge in this court that you shouldn't believe these sisters. They're just flown in to give their big brothers an alibi. But you would never write that down. You know, it sounds like discrimination, it's soft information, it's intuitive.
Sounds like.
Sorry? Sounds like, yeah. Yeah, well, we can discuss that. But, so if you would make this information explicit, it would only fuel a huge discussion and an endless discussion and weaken the authority of your decision. So, but it is used, this experience and this assumption, it is used. So, and I can give many more examples of this kind of experience, you know. And so my question is, just apart from this example, maybe this is not an example that you would like to use, but how should we give this information a place in the whole argumentation? You know, can you give it any weight? How much? And I suspect the legal answer is probably different than the rational one, because it sounds like discrimination and everything. But I'm curious what the mathematicians or the Bayesians in this room think of it. Could a judge use this information? Should he, and how? Well, can't wait to discuss that with you later on. I can't wait to do loads of further research, because I think that's really necessary on this topic. But I also hope that I've made clear that if you want to incorporate probabilistic reasoning in law, if you would want to do that, and you want it to be relevant, you first have to know about what a judge does. You know, you have to have knowledge of the law and daily practice, and then only then you can maybe convince judges it can help them, and only then it could be relevant. Thank you.
Yes, Jane?
I think your final question was all of the talk was very interesting. Your final question is very interesting. Because, of course, freedom of speech in Britain means there are certain topics we're absolutely not allowed to discuss or do research on. So, for example, if somebody in the Greater London region wanted to do an analysis of, say, the ethnic background of different criminals, they might well find them very difficult. And yet I don't find the idea very difficult that the culture that I grew up with is different from, say, the culture of Kenya, where I spent time.
Yeah.
But those kinds of things, quite often you're not allowed to look at the information. In Switzerland, there's good information on the characteristics of convicted rapists. But to take the question further, it's just not allowed. And clearly you need to take that question further to get the denominator. But of course you're not even allowed to do that.
But it is used as kind of information, you know.
Well, the point is it better to be allowed to pose the question, are there different social conventions in different communities, or should you not even be allowed to ask the question? So what is allowed in evidence?
It's not allowed in evidence. This is not allowed in evidence, but it plays a role in the inner conviction of the judge.
Yes. Well,
as Jane said, this is a very important issue because this is a lot of things like these that are going on in the courts that you can't see in the verdicts. That courts, judges know that certain ethnicities are overrepresented in crime statistics. But you can't write that in a verdict. You can't say, okay, so the defendant is of Somalia and now he is, and we know that Somalians are overrepresented and therefore that's some kind of circumstantial evidence. That, I mean, a judge in Scandinavia at least would never write that in a verdict, but they would discuss it in the coffee room and they would probably be influenced by it. So
isn't the problem then that when they do write their verdicts, the arguments for their verdict, it won't make sense because their verdict is depending on things which they're not writing down.
Exactly. Yeah.
And then there will be an appeal and so on and so on.
Exactly. But I think there are several good reasons for why this shouldn't be taken into consideration. I mean, one thing is, for example, that there could be a selection bias problem going on here. That the reason why Somalians are overrepresented, one of the reasons, is because the police are more attentive towards Somalians, and therefore they are more often suspects than others than Danish or Swedish born people, etc. And so you could have that kind of explanation going on. You could also have another reason would be that you could say, if you would admit this, you would say even if it has some small probative value, there is such a great risk that it will be overestimated. So it's better that it's not considered because the prejudicial effect will probably be greater than the probative value. So I mean, there are lots of reasons why judges and jurors shouldn't do this, even if it does epistemically have some kind of probative value.
Okay, well, there's a lot more questions there, Joe, and then the one that. But we can come back after tea.
I think however, you said that the judges have seen this particular alibi quote used awful much more frequently, intuitively. Now, as a statistician, I of course would say, let's get some data. You have cases, and then you can spot which alibis are being so overused in terms of everything else compared to other similar cases. Then you could put some kind of legitimacy. Whether we could put a complete probability model on it, I'm not so sure, but we probably could go pretty far with this group. So I think the basic thing here is the lack of real solid information.
Yeah, I think so too, but I don't think you're ever going to get it, because that kind of research would never be allowed.
When you get these data, do you keep them secret, Joe?
No.
Well, if you tell anybody, they won't use the alibi anymore.
I think
I'll let you lawyers decide what to do about that. At least you can.
last question? Yes?
I don't think I understood your point about the judge who developed two different scenarios to explain the evidence. One scenario was consistent with guilt, and the other with the defense theory. And you said the defense scenario the judge decided was less plausible, but it couldn't be ruled out.
Oh, that one, you didn't answer.
Right, and so so it seems to me that if there's a theory of the evidence that's consistent with innocence that cannot be ruled out, that sounds very close to what we're talking about by when we say reasonable doubt. And so is it really a mistake? So I want to hear more about your argument for why it was a mistake for the judge to take that scenario.
But if you think that's close to reasonable doubt, then reasonable doubt for you is a very high standard of proof, because to me it seems cannot be excluded. It seems that I have to be 100% sure.
Yeah, because
that's what it sounds like to me.
And the point was that there was no attempt to quantify the uncertainty. It was just to say it exists. We haven't disproven it absolutely.
Yeah.
Was there some kind of
It's
evidence?
too absolute. Yeah.
Backing up for this.
Sorry?
Did the innocent scenario have some kind of backup to it, or was it just totally fabricated?
The
innocent scenario.
So I don't know that.
Bandit.
Yeah.
Because to me, I mean, I
That's
agree.
very relevant, but I don't know.
I agree with Phil. I'm thinking if the guy's got two scenarios, I mean, I find it weird to have two scenarios anyway, because there's millions of scenarios, an infinite number. But if he's got one scenario that is equally that you just can't rule it out, it's entirely possible, then the guy has to walk. I don't see how he can.
It doesn't even have to be equally plausible.
No.
I mean, suppose that we think that the evidence is 10 times more probable under the prosecution scenario than the defense scenario.
But he didn't consider the prosecution scenario. That was
He
the
didn't.
thing.
Yeah, he didn't consider.
Only
it.
considered.
Yeah.
Only it's cherry picking an
That's the
alternative
whole,
scenario, focusing on
you know,
that. And
The
that's
point of there was no assessment of the relative
Yeah.
weight.
That's my point. There was no assessment of the relative weight. What judges normally do is only look at the guilty evidence, and not look at the not guilty evidence. But now he just did it the other way around.
Well, okay.
That was actually,
Very convincing argument, but you've just contradicted your other point, which is maybe judges shouldn't be thinking like Bayesian, right? So now-
I see there's lots more things. We can
It was a really good story.
Let's